Was a very interesting experience. I don't have the world's best memory, but I remember arriving in Egypt.
Welcome to one of our best, or rather fondest interviews we're gonna have today. Ladies and gentlemen, we are at the hospitality of Professor Jason Beckett. And for those who've been in Cairo for a long while, Professor, you're, as we say it in Egypt, أشهر من نار على العالم. Everyone knows who you are. Everyone really wishes they would have a session with you, whether as a motor, as I used to be years ago, or as a student as yet have been. But I have to say, we have a lot of questions that has to do with you. Practically, you're our 007. We have a lot of questions about your background, and we have a lot of questions about your thoughts. For those who may have not known Professor Jason, um, Professor, you've been teaching international law and jurisprudence at the American University in Cairo for quite some time now.
12 years now.
For a few years, I frankly thought it was longer. And you've always been a regular to any initiatives that has to do with the development of students' mindset, especially moot courts, and with all the spectrums from international arbitration to international law. So, with that on the air, I want to go back a bit as a starter with when you first landed in Cairo. I mean, it's a bit of a long way from the UK to Cairo, and it's been 12 years, and there is a bit of mystery earlier than that. So, how was it like first landing in Egypt?
Was a very interesting experience. I don't have the world's best memory, but I remember arriving in Egypt. So I got the flight from London, I got to Cairo airport, and I got off the plane, and there was a little old man who must have been like 103 with a sign with my name on it. And he seemed to know everyone in the airport. So he walked me to the place where you buy a visa, and they opened a new line so that I could buy a visa. He walked me to passport, and they opened a new booth so that I could go through passport control. He took me out to, well, we got my luggage obviously, and then to the car park where the AUC had sent a driver to pick me up. AUC cars were a bit different back then. It was a battered old Jeep that picked me up. But the strangest thing, and the reason I always remember it, is as soon as we got out of the airport, as soon as we got off of airport land, the driver pulled into the side of the road and reached into his pocket. And I was like, what is going on? And he produced an envelope which turned out to have 10,000 Egyptian pounds in it, which 12 years ago was actually a lot of money. And that was the only two words he knew. He said settling allowance. So this was my little gift from AUC to help me settle in. So I felt very appreciated. And he took me to what used to be the AUC dormitory in Zamalek. I think it's now called the Icon. It's been refurbished as luxury flats. And I went in, and they said, who are you? And I said, I'm Jason. And they said, oh, okay, have a seat over there. So I went and had a seat. And about 30 minutes later, someone came over and said, we don't know who you are. We have no record of you being due to be here. Are you sure you're in the right place? And I said, no, I've never been to Egypt before. I'm sure this is where the car dropped me off, so I hope it's the right place. And I sat for another 3 hours getting increasingly worried. And then someone else came over and said, Professor, there's been someone from housing waiting upstairs for the last 5 hours. Do you think he might be waiting for you? I said, well, I don't know. I mean, it sounds possible. If he's waiting to give someone a house and I'm waiting to receive a house, then yes. And he was. And he showed me around this really spectacular apartment. So before I came here, I was actually visiting at Sciences Po in France, living in Paris. And my apartment was 14 and a half square meters. And then I moved to this AUC apartment and my lounge was 55 square meters. It was like moving into heaven.
Oh boy. But aside from the military style or intelligence style settling in experience, well, that actually gives me a bit of intrigue. So you've been mostly working out the world, practically, other in Europe or other parts of other regions, but never in the UK?
I did. So I studied obviously in Scotland and I taught in Newcastle University for 3 years and then I taught at Leicester University for 5 years.
Okay. And most of your career been in academics mostly?
I left academia once for a year and it was horrible, so I came back. And yes, I've never left since.
Wow, that's a lot to absorb at one point.
Can I get back before you reach the airport in the plane? Can I know what was your feeling coming to maybe a developing country or a third world country, and what was your goals? Maybe what was your plans and your feelings that you're visiting Egypt?
So I arrived in August 2011, where the very positive spirit of the revolution still existed, and the revolution had been so positively portrayed in UK media that I came excited. I was coming into a moment of revolutionary change. Things could really get better. But also, and I think it's important, I only came for a year. I was on a 1-year visiting contract.
Okay.
I had a leave of absence from Leicester University for a year. So I came assuming I was going to have a year in the sunshine, teach exciting people, see the aftermath of a revolution, and then go home.
Okay, this is so interesting. So now it's a new story. Like you was planning for 1 year and it's become 12 years.
13 now, this is my 13th.
This was 13. Okay.
Actually, that gives me a bit of an intriguing aspect of it. Is what made you decide, if any, to stay for 13 years now?
3 reasons. The most important reason is that I met the woman I'm now married to. Second most important reason is I actually enjoy teaching at AUC much more than I enjoyed teaching in the UK. And the third reason is the weather. I'm from Scotland. Living in permanent sunshine is my idea of heaven.
Okay. That's weather. Obviously today is not how it should be, but well, and on that actually, it's a question I always had when I first met you back in 2016. It's like, why international law?
Why international law? A lot of it is chance. So I was not a very good student. My attitude was poor, my grades were poor. I really didn't like law school, and I didn't like this educational system where I had to remember rules and cases, and everything was very mechanical, and I didn't have the memory to do it well. The one subject that stood out for me actually was jurisprudence, which I studied in my second year, and it was the first subject that I enjoyed at university. And the professor who taught jurisprudence happened also to teach international law. So I took international law with him in my third year and discovered that it offered me a lot more intellectual flexibility than Scots law as I had been taught it up to that point. So then I dedicated my fourth year of university completely to studying international law, to work with this one professor, Ian Scobie. And Ian left. He moved from Dundee to Glasgow, and I was left without my reason for doing the subject. He was replaced by someone perfectly competent, but I didn't get the same feel. And then I graduated, and I spent a year teaching and researching in Dundee University. And then I had that traumatic experience of leaving academia, and I actually worked for my government as a legal researcher, which I did not enjoy. And while I was doing that, to my huge surprise, Ian Scobie, the guy who had abandoned me to move to Glasgow, called me. And this is a long time ago. This is in 1997. So mobile phones were not a thing. He called me on my phone in my office, which was particularly strange as I hadn't given anyone the number. And he asked how I was enjoying my research job, and I lied and said how good it was. And he asked again, seriously, and I said, it's horrible, no one here likes me, my work doesn't fit in, I need to get out. And he said, well, that's great, because I've set up a master's program in Glasgow and I want you to come and take a place on that. So I did my master's in international law, and that was my first university experience of really excelling at something. Like, the game just made sense to me. And then I got offered the chance to write my PhD, and I needed a supervisor, and I went with Ian Scobie again. I don't know if this is something I boast about or cry about. I applied to Cambridge for my PhD because I had a full scholarship from the government. I had a really good project. It's Cambridge law. It's where my supervisor studied. And so I wrote full of hope and anticipation, and I got a letter back that was literally one line long, and it said, the law school has rejected your application. Not dear Jason, not dear Mr. Beckett, not good luck in your future endeavors, just one line, the law school has rejected your application. And Ian stepped in and agreed to supervise my PhD, and that was it. International law chose me.
Oh my. Well, when you said intellectual flexibility, did it happen to be the same experience in the PhD phase?
Now, my PhD phase comes in three parts. So in part one, for 3 years, I was a full-time PhD student in the University of Glasgow. And all I was doing was my PhD and my teaching. My son was very young at that point, and he went to nursery at university. So I would take him in the morning and pick him up in the evening and take him home. So I had a very structured life for a PhD student, and my son was a reason to see that the PhD wasn't that important. It was just another test that I had to pass. Unfortunately, after those 3 years, my funding ran out and I hadn't submitted my PhD. So I got a job in Newcastle. I moved to Newcastle. I continued to write for another year. And my PhD My PhD was an exploration of the ontology of international law. I was trying to work out what customary international law was. But it was also in large part a reaction to Marty Koskiniemi's critique of the indeterminacy of international law. And I published a summary of my critique of Koskiniemi in the European Journal of International Law. And I really hadn't expected them to accept my paper. I was looking for a positive rejection with useful feedback, but they accepted my paper, and I decided to write to Koskiniemi and say, this has been accepted for publication. It's a fairly direct critique of your work. Do you want to look at it? And about a week later, I got an absolutely delightful email back from him saying, it's a great piece of work in the finest British analytic tradition, blah, 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 blah. Very, very sweet. And then, but this is how you've completely misunderstood my work.
Oh boy.
And then he explained the outline of his work, and he sent me a copy of what would become the epilogue to the second edition of From Apology to Utopia. And bear in mind at this point, I've just finished 4 years of my PhD, effectively refuting Koskiniemi. And I reflected on his email, and I read the epilogue, and I had this light bulb moment of thinking, oh my God, he's right. He's not wrong at all. I'm wrong. And so the final part of my PhD was trying to teach full time, trying to complete my PhD knowing it was wrong, and trying to force myself just to write. So the start of the PhD was an amazing experience in broadening my horizons. And the end of the PhD was the point where I began to transition from being a mainstream international lawyer to being a crit.
Why this like an Ouroboros cycle man?
But I would love to know when we're back to the point, what kept you going? Like, I understand that you have a rejection from Cambridge, which was you're looking forward for it. The funding stopped, and you have to have a new job. And I believe pursuing the academic career and studying a PhD for 4 years in research, it's very hard with some obstacles like funding cut or rejection from university. Yeah.
I mean, as I say, I was very lucky. I got a spectacularly good scholarship from my government. I started my PhD in 2000, in the year 2000. And my stipend was the same as PhD students are being paid now in 2023. And the stipend was guaranteed for 3 years. During those 3 years, I fell in love with teaching, and I realized I was good at teaching. And I don't come from an academic or a professional family. My brother and father are carpenters. My mum was a secretary until she retired. And academia seemed like a perfect job for me. I had, on the one hand, the right to teach, and on the other hand, a large degree of freedom in my research. With the PhD, it was a requirement of my contract in Newcastle that I completed the PhD within 3 years of joining Newcastle, or I would lose my position. So essentially a mixture of desire and desperation.
Okay, so now that we're talking about teaching, there is this misconception that sometimes hits our heads, maybe especially if we're not broadened in terms of academics. What is the core principle of jurisprudence as a subject? For people like me who has not been in the academic side, or its good side at least, It's more of our understanding that it has to do with the opinions of publicists, for instance. But the way that Ziad has been talking about it as someone who studied with you, it's an experience rather than just a subject matter. So,
Yeah,
More than that. There's more stuff after the class. And then what we do? Like, how can we solve this?
I teach a course called jurisprudence, but I don't particularly like the word jurisprudence. So jurisprudence translates as the wisdom of the law. And jurisprudence, as it's generally taught, is a system of explaining why the law is good and just and necessary. And what I try to do in my course is to take a step back and ask, is the law good? Is the law just? Is the law necessary? So I see my course more as a philosophy about law than an intrinsic worship of law's wisdom. But nonetheless, I still teach a collection of articles by writers I think of as publicists. I just have a very different canon of writers than a lot of other jurisprudence professors.
so what would there be the characteristics of such writers? Is it that they're more on, for instance, the free thinking side? Is there like a characteristic you can define?
Yeah, I mean, almost everyone I teach is on the political left from a European or an American standpoint. I choose scholars who are critical, who ask the foundational questions instead of assuming the easy answers. So I teach sort of class-based neo-colonial critique of international law or law. I do a feminist critique of law, I do a race theory critique of law, an intersectional critique of law, sometimes a cultural pluralist critique of law. And what I want to do is very much disturb the assumptions that law is somehow technical and that law has some necessary relationship to justice. I want people to look at law without assuming that it's beautiful. Let's look at it as it is, and then we can decide if it's beautiful or not, or wise or not, or just or not.
Maybe it's a lot to absorb. Well, maybe on such an aspect, would it be a bit accurate if we're addressing such a point to say that you would want people to, with the subjects of international law, shifting a bit to international law, so the actual subjects of international law should decide whether law in general and the international law is the tool they should be using? Like the actual subjects, the people, the groups?
I think, in a way, yes. So I think my views on international law have changed diametrically over time. I started out very much in the British positivist tradition, that international law was a set of relatively determinate, tolerably just rules that you applied to objectively analyze events in the world. I've subsequently come to the conclusion that none of my definition of international law was correct. Paradoxically, international law manages to be both radically indeterminate, it can be used to say anything, and yet structurally exploitative at the same time. So you can use international law to make any argument, but the arguments that unfold as policies in the real world are remarkably consistent. So personally, I don't hold out much hope for international law as a progressive or an emancipatory system. And recently, over the last 2 years, I found this a very disquieting experience, but I've begun to really question whether international law is law at all. I've gone all the way back to H.L.A. Hart in 1960, whatever, saying there are no institutions, this is not a legal system. But equally, and maybe we can come back to this, I've come to the conclusion that there are two different kinds of international law. So there's the textbook international law that we do at Jessup's, and that's interesting and nice and fun and radically indeterminate. And then there's this other law that I now call the global legal order, which is tentatively the IMF, the World Bank, the World Trade Organization, and the system of international investment arbitration. And these are very different to international law because they have institutions and they have officials and they have the power to punish states. So if you don't comply with the IMF, they stop your loan. If you don't comply with the World Bank, they stop your loan. If you don't comply with the World Trade Organization, they authorize sanctions against you. If you don't comply with international investment arbitration, the awards are enforceable in any national court in the world. And what's interesting about these four institutions, particularly the IMF, the World Bank, and the WTO, is that they work very closely together. And people move very freely between them. And they're dominated by a neoliberal ideology that I think has been incredibly bad for the underdeveloped world.
When you say it's incredibly bad, is it because it mostly functions on a mechanical side of them just simply lending and asking for interest, or that they simply meddle in how these repayments of loans should come with structural changes?
Yes, it's mainly this. So it works on two different but interrelated levels. So the biggest problem with IMF and World Bank loans is the conditionalities that are attached to the loans. And the conditionalities demand a neoliberal market reform. And the IMF has been imposing these conditionalities for almost exactly 40 years. The first neoliberal conditionalities were imposed on Turkey, I think in 1983, I think it is 40 years ago. And in the subsequent 40 years of IMF intervention across the global south, to my knowledge, and I might be wrong, not one state that the IMF has intervened in has got any better off. In fact, they've all got poorer than they were before they started imposing the IMF policies. And this is controversial, and I don't want to go into it in any depth, but the reason for that, as far as I can see, is that neoliberalism just isn't an economic theory. It's a political ideology that concentrates wealth in the elite. And that is literally the last thing that underdeveloped states need. So you have this government by remote control over the entire economy. And at the same time, you have a system of well disguised but massive exploitation. So in, I think 2016, Global Financial Integrity, which is an NGO, and the Norwegian Institute for Economic Research, did this fantastic research on cash and resource flows between the overdeveloped and the underdeveloped states. And what they discovered is that in 1996, in total, the overdeveloped states transferred $2 trillion to the underdeveloped states. That's aid, investment, loans, and actually remittances are very important. So like Egyptian workers in Europe sending money home. But $2 trillion net moves from the overdeveloped states to the underdeveloped states. But at the same time, $5 trillion move from the underdeveloped states to the overdeveloped states. So in any given year, the poor states of the world literally give the rich states of the world $3 trillion. And that's the underlying problem. So when I think about development, global development aid is about $110 billion a year. So we take out $3 trillion, we take out $3,000 billion, and we give $110 billion back. It's like me walking into your house at dinner time, sitting at your dining table, taking your plate, eating it, handing you the last piece of broccoli and expecting you to be grateful for it. Because it's a ridiculous system.
This obviously hits deeper than what people speculate generally. That
Yes.
They're only with short-term projects and whatnot.
No, the global system, with a very brief exception from 1950 to 1980, has been structurally oppressive to underdeveloped states for 400 years.
Well, mostly that has to do with this part now that we're at it. So in light of the Russo-Ukrainian conflict and the obviously ongoing situation that is going from the 1940s in Palestine, and a lot of those issues that may be called a matters of international law, and in light of the new world order, if you may call it, is it unfortunately safe to presume that the international community has actually lost its grip on handling problems the proper way? If any at all, at this stage.
So as you might have guessed by now, I'm not a big fan of the international community. And I'm trying to think how to bring all the aspects of your question together. So the contrast, obviously, between Ukraine and Palestine is a very, very interesting contrast. That you have, at least at face value, two states carrying out aggressive invasions of other states. In one case, the invasion seems to be essentially accepted and has become normalized. And in the other case, the invasion is somehow aberrant and must be punished. With Palestine, I have very little optimism. But strangely enough, one of the few things that makes me vaguely optimistic is actually the international law that I usually dismiss. I don't think this will happen. It's a possibility that allows me to sleep at night. So as you may know, the International Criminal Court have opened an investigation into activities in the territory of Palestine. And obviously, it's typically ICC even-handed that they're looking at the activities of the Palestinians and the activities of the Israelis. And I think what will happen is that they will charge Israel with war crimes. And we'll see a handful of people punished for a handful of specific events, which would be better than nothing, but not great. But more recently, there's been an argument that what the ICC should do is to prosecute Israel for the crime of apartheid as a crime against humanity. And so not to prosecute them for the occasional spectacularly bad things they do to the Palestinians, but to prosecute them for the everyday quiet bad things that they do to the Palestinians. And I think that an apartheid charge could potentially make a huge difference in the way that that conflict is perceived by Europe. Palestine is always going to have the problem of the United States of America. And I really don't think evidence matters when it comes to American support of Israeli policy. With the Ukraine, my goodness, I don't know what to think of the Ukraine. I hate the fact there's a war going on in Europe. I hate the fact that it's important that that war happens to be in Europe, and so we talk about Ukraine instead of talking about Yemen or Syria or Palestine, or Ethiopia or Rwanda or.
The list goes on.
But, international law has always had a difference of standard when it comes to the treatment of white people and non-white people. And I think that that is baked into both the coloniality of international law and the unspoken racism of the European and American projects. So I'm, as I say, vaguely hopeful for the ICC, which is a very strange experience for me. And Israel was the first ever ICC investigation that wasn't centrally concerned with a black African man. So it was the first time that the ICC opened investigations into white people. And that's a little bit optimistic. Will they have the courage to go for apartheid? I don't think so, but it would be wonderful. Similarly, will we beat Putin in Ukraine? I have no idea, but it would be wonderful. I don't like armed aggression, regardless of who the aggressor is.
The only thing we could say is we would hope for the best at this stage.
Yeah, I just don't know what that is. Seriously, do you compromise on Crimea and try to get a withdrawal from everywhere else? Because I think, historically, the claim to Crimea is slightly different. I don't want to be a Putin apologist, that would be a terrible thing. But Crimea was gifted by Nicholas Khrushchev from Russia to Ukraine, I think in 1953. It's not been a part of Ukraine forever. And it is geographically different to Ukraine. So I could see an argument for saying, give Russia Crimea if they will withdraw from everywhere else. And I see the argument that says, if you legitimate any territorial conquest, then they'll just come back for more later.
And the list will go on.
Yes.
That's one situation we hope all those situations will end one day.
One day. And also the potential knock-on effect that has on grain supplies across Africa is terrifying.
It's already been starting to hit critical aspects.
Yeah.
Don't know where to go from there. But on a bit of the lighter side,
yes.
what do you think of moods as an essential, or if you think of them as an essential part of developing the skills of whoever wants to get into law in general, either as a practitioner, as an academic?
So first and foremost, I think moots are simply a wonderful experience for students. And it's not a talent that I have, but a well-constructed moot problem is such a fun intellectual game. So I think moots are very important in that they show students both the plasticity of law, how manipulable legal arguments are, but also the formality of law. That on the one hand, you can argue anything you want, but on the other, you have to argue it in a very specific language that the court will understand or the court will accept. So I think that they're excellent exercises in learning how to manipulate law. They're excellent exercises in learning the rhetorical skills that lawyers need. And when they're done well, and this is the most important for me, they're excellent exercises in building student self-esteem. People learn from mooting and they become better students as a result of doing well or even not that well at mooting, as long as they're encouraged. It encourages you, I think, to think about law in a much more sophisticated way than the law school, here's the law, here's the facts, here's the answer. Because with the moot, you always have to say, here's the law, here's the facts, here's the answer, but here's the law, here's the facts, here's the other answer. That's exactly the opposite of the first answer. So you learn that law is a discourse, a language that you can manipulate and use and play with. And I think that's really important to lawyering.
It is indeed an important part of lawyering. So maybe on that side as well, do you see yourself really wanting to commit to more moots, maybe as other aspects?
So I very much enjoy judging moots. And I particularly enjoy Jessup's because the problem is always so very well thought out and presented. But actually my favorite moot is the African Court of Human and People's Rights moot, which is an undergraduate moot that takes place in a different African city every year. It's much, much lower budget than Jessup. It's much more homely than Jessup. But also the teams are only 2 students. So the same team has to argue both sides of the argument rather than Jessup where you split it into your appellant team and your respondent team. And it's such a strange experience for me because the students from sub-Saharan Africa take this competition incredibly seriously. And I don't. I see it as a nice excuse for my students to travel somewhere and meet new people and compete and see how we do. But with a lot, particularly of the South African universities, there's a lot of pressure to win. And being able to judge in that moot and try to take some of that pressure off of people and let them perform at their best rather than panicking is a really pleasant experience.
True that. And maybe on the same side as well, Are there any other similar projects that we might expect you at? So maybe other research projects, other competitions of any sort?
I mean, hopefully I'll do the Jessup again. I didn't do the FDI moot this year. It clashed with me being out of the country, but I'll do that again.
I would have saw you there.
I'm usually invited to GUC for their internal moot. And there's one more.
Yes, my cousin is the first year student in GUC and she suffered a lot. She's suffering.
It's a Price Cooper media law debate.
Nice. The one with the Oxford.
Yeah, that one. So I like judging in those finals, and I like coaching my African moot team and judging my African moot team. But that's enough for me. At the moment, I'm actually having an unusually productive spell of writing, and that's taking up most of my time.
And can you expect any publications soon?
Yeah, so I've had 4 in the last 2 years, and I have 2 projects that I'm working on that are very, very different to anything that I've done before. So most of my work since about 2012 has been on how international law does horrible things to poor people. And I think that work is really important, but at a certain stage it becomes very difficult to motivate yourself to read another version of the IMF plundering a country, another version of the WTO destroying a working system, another version of the World Bank saying governance reform. So I've taken a complete step back. I'm writing a paper on the sources of international law, which is aimed primarily, if I can find a publisher, at mooters, undergrads and mooters. So it's a paper showing how inconsistent primarily the ICJ is in interpreting treaties, in identifying custom, in using general principles. And I'm enjoying that paper. It's very light-hearted, but I'm having trouble publishing it because it's very light-hearted, and apparently academic work has to be serious and boring or else no one will read it. I don't understand this, but that's what the journals tell me. And the other project is a very foundational feminist critique of law as the embodiment of male rationality, and trying to think what a feminist legal system would look like. So it's really nice to be working on positive things for a change.
And have you ever thought about writing non-academic papers, maybe something to students, ordinary people?
I've written a couple of blogs at times. I don't like writing blogs just because they're too short. I don't feel like I can say enough in the space that I have. But I like the freedom that I get to write in a less academic way. So what I did was summarize some of the big papers I had been working on into much more manageable blogs, or I wrote a piece for the Cairo Review of Global Affairs, AUC's in-house magazine. That's, again, it's somewhere in between. It's not as playful as the blogs, it's not as serious as the proper work. I would like to do more of that, and maybe, so I don't know if I told you, but I got tenure and I wasn't sure that I was going to get tenure because I wasn't sure that I had published enough. And things like blogs don't count at all towards how you're assessed for tenure. So I had to very much focus my energies on publishing in proper academic journals so that I could keep my job. Now I have my job, I can publish for myself a bit more.
Okay, yes, because I believe it would be very interesting for all the students and the students to read a book from you for practical thinking and like your lectures, like everyone to read it and see it like a lecture, not really subject to academic standard.
And I would love that, but I don't know if I could write a book. Honestly don't know if I'm over the trauma of writing a PhD 20 years ago.
Yes, I understand that. Also for this, I want to know how you see the students' emotions. As you said, it's very good for lawyering. And how do you see the future of lawyering when you look at that? And maybe if you have any, especially in general, you want piece of advice for them to understand things better and be better for learning?
So I think with moots, I like students who are creative. I've always had this theory of mooting that not all of my colleagues agree with, but I have this tendency to think that I'm right. And I think that with a moot, if the law is on your side, you ought to lose. And if the law is against you, you ought to win. Because if the mainstream reading is on your side, then you can only do two things. You can either present the argument competently, or you can present the argument badly. But if the law is against you, that's where you have the chance to be creative. That's where you have the chance to do something exceptional rather than competent. So I think my primary advice to mooters, and this is actually what I wrote the sources of paper about, is be playful, be confident. And especially in international law, you can literally make the law say anything that you want it to say if you have faith in yourself. And so much of mooting is about self-confidence, but equally mooting is so good for self-confidence. I think it's a fantastic way for students to grow. I used to teach using a lot of mooting. And the only reason I changed that is I don't teach the rules of law as much as I used to, rather than the social impacts of law.
Okay. And we have a lot of feedback that in your mood judging and questions, it's not always based on the facts of the case, like you go deeper with them to see their beliefs and thoughts. So do you believe for preparing for mood you should read a lot about the major principles of the law, and he should believe in the case himself, not only to follow the law and the rules, so reading more at the major concepts?
Yeah, so again, I can only really talk about international law because I was a very poor student of domestic law. But I think that the rules of international law are completely elastic. So, if you take a sort of simple example, the rules on interpreting treaties, Article 31, 32 of the Vienna Convention on the Law of Treaties. Article 31 has a really simple rule. Right? Read the bloody treaty. Don't add any words, don't take out any words, do what it says, which is great. Article 32 says, if you don't like the outcome of reading the treaty, if it's absurd, then you can look at the preparatory materials and outside influences to see the meaning of the treaty. And then returning to Article 31, it says if that's still absurd, then you can turn to the object and purpose of the treaty and interpret the treaty in its light. But what happens when you interpret in the light of the object and purpose is that you have to add and remove words to realize the purpose. So what we have is rule A of treaty interpretation that says do not add or remove any words, and rule B that says feel free to add and remove words. When you put those two rules together, you can do anything. And treaties are the clearest part of international law. You know, things are much murkier when you go into customary law or general principles. So I think the difficulty for Mooders is that they have to realize that international law isn't really a system of rules, but they still have to present as if it was a system of rules. So the key is to realize that the rule that you need to support your case exists. You just have to be clever in finding it. And real courts do this. Let me give you an example of a real court that I teach occasionally, which was the South African Supreme Court, or Constitutional Court. And as you probably know, South Africa has the second most beautiful constitution in known legal history. As you might not know, the only constitution that was nicer was the 1934 constitution of the USSR. So Stalin's first constitution. If you read it just as a document, is a beautiful thing. The South African constitution, if you read it just as a document, is a beautiful thing. And it's a beautiful thing because it has a lot of positive rights in it, including, in particular, for this example, the right to water. And despite having the right to water in the constitution, the South African government, under pressure from the IMF, privatized water supply across South Africa. And the private company installed water meters so that people had to pay for the water they got, and if you didn't pay, your water got cut off. And so a group of people and NGOs challenged the privatization as a breach of the right to water. And it went to the Supreme Court, and the Supreme Court said three things which were interesting. Two of them, lots of people spoke about, and one of them, very few people spoke about. So the first thing they said is the right to water is a real right. And the second thing they said is the right to water is justiciable. It can be enforced in this court. But the third thing they said, and this is the interesting bit, is the right to water isn't a right to any particular amount of water. So if the water company gives you the first liter a month free, that's your right to water. So they've taken a perfectly clear rule and said, yes, it's justiciable, yes, it's a real rule, but then they've taken all the meaning out of it. Yes. In a similar case, they made this dramatic conclusion under the right to housing, that the right to housing is not the same as the right to have a house. It's actually a procedural right to assume that in a reasonable period of time, the government will develop a reasonable policy to provide housing for everyone.
Yes. No one gets a free home, as they call it.
Well, this comes from a case called Grunebaum. And what was interesting was that Mrs. Grunebaum had a home. She had a home in the Shlomo shanty town, I think outside of Cape Town. And the government sold the land of the shanty town to property developers and then bulldozed the shanty town. And she claimed that destroying her house, was a breach of her right to housing. And the Supreme Court disagreed. They said it was rational for the government to sell prime land in order to buy inferior land to produce housing for the poor. So actually having her house destroyed was the realization of her right to housing. And again, this is why I want people to see the playfulness, the potential absurdity of law. because the bad people already see it. They know how to do this. It's the good people that need to catch up.
So everyone needs to be on the same level in terms of how the mechanics work.
Yeah. So, I mean, it's like the legal realists really emphasized. It's not what the law says that matters, it's what the courts do that matters. No one cares what you think the law means. Everyone cares what the Supreme Court thinks the law means.
What you can present a court. Very well. Well, in the conclusion of this part, Professor, a lot of our readers, well, they seem lost. You know how uncertainty strikes when you work in law. So, is there any words of encouragement you want to give, especially to our younger readers, those who are just to be professionals or about to be professionals?
2 levels. One is that I've never really been a legal professional. And the other, which is one of the reasons that I enjoy teaching at AUC more than I enjoy teaching in England, is I don't really see my job as producing legal professionals. So I haven't looked for statistics in Egypt, but when I graduated from law school in 1996, when I graduated from law school, less than 40% of law graduates ended up in the legal profession. And since then, the number of law graduates in Scotland has more than tripled. The number of jobs hasn't. So it's maybe 20% now that are going into the legal profession. So I would say, one, remember you have options outside the profession. It's a really useful degree. It's a prestigious degree that teaches you important and transferable analytical, rhetorical, and presentational skills. If you do want to get into the profession, and the advice is always the same, and I don't particularly like it, work hard and don't be afraid to advertise your own brilliance. No one else is going to blow your trumpet if you don't.
Yeah, I'm glad I heard this information 5 years later. When I first did something similar, I was like, am I doing this the right way? But now I know it was.
Yeah.
Well, now we're more into the serious part of the
Yeah, I know we've been too long, but I'm trying.
It's okay.
So I guess from the answers, maybe the audience and the readers will understand that you have different views on that. It was very obvious how, like, this one part strike me that, especially in our developing countries, that the law is going to the power, shifting the power to the elites.
Mm-hmm.
And I wanted to know why, especially in developing countries. Maybe we'll go with this one first, because I really want to know what's in this part.
Okay. So I think, first of all, it's important to realize that law has almost always represented the interests of the elite. And that actually we have all, pretty much everyone who's alive, has grown up in a very unusual period of world history. And I loosely date that period from about 1930 to about 1980. And 2 different things happened in this period. One is that in the rich states, in the overdeveloped world, you had a transfer of wealth from the rich to the poor. So in America, it was the New Deal and the promotion of unions and federal jobs and well-paid jobs and the provision of public libraries and public highways. But it was a huge investment in the working class. For being picky, it was a huge investment in the white working class. The African Americans were excluded from the deal. In Europe, it took a little bit later. It started after the Second World War. But again, we began to develop welfare states, national education, national health care, national universities. And again, we redistributed wealth from the rich to the poor. But we've had law for, I mean, depending on how you look at these things, 3,000 years, 2,500 years, 6,000 years, 12,000 years. In those however many thousand years, we're talking about 50 years where money moved from the rich to the poor, and then several thousand years where money moved from the poor to the rich. But the situation in developed and underdeveloped countries is different. It's becoming similar for reasons that I don't understand. Developed countries still adopt neoliberal economic policies, which evidently make people poorer. But the one saving grace, again, I don't like it, but the one saving grace is that they do this by choice and people vote for them. So I have a limited degree of sympathy. But things are very different in the undeveloped world, because here the neoliberal policies are imposed by the IMF, they're imposed by the World Bank, they're imposed by the World Trade Organization, they're policed by investment arbitration. Now, my sort of sweeping argument about international law is that international law has always been a colonial project. It was created to justify and regulate the European colonization of the non-European world. And I don't think that has ever changed. So we went through a period of open colonialism, and we still have to reckon with that period. So let me give you 3 figures out of that period. I've come to like numbers. 165 trillion US dollars. That was the value of silver that Spain plundered from the Americas between 1630 and 1870. So one resource from one half of one continent, $165 trillion. That's more than double the global GDP. Recently, I read a really interesting document called the Brattle Report, which was commissioned by the American Society of International Law and the University of the West Indies. And it's a report trying to calculate slavery reparations. And it's a really irritating report to read because it's so conservative. So they'll say things like, when economists are calculating interest over time, they usually use 5% compound interest. But just in case that's controversial, we'll use 2.5% compound interest. So everything is minimized, 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 minimized. They don't look at compensation that should be due for the trauma of slavery. They only look at the economic wealth that was stolen in the transatlantic slave trade. And they figure that reparations should be $130 trillion. So the chances are is more than double that. Final number is $45 trillion. And that's the amount that Britain stole from India. So what I want you to see is that the scale of wealth that was stolen during the colonial period is literally unimaginable. So if you think about, if we could get away from politics and think in really geographical, geological terms, Europe is not a rich continent. It doesn't have major reserves of anything important. It has a little bit of oil and some coal, but it shouldn't be rich. The reason it's rich is the money that it extracted and continues to extract from elsewhere. In the 1950s, we began this very peculiar process that we call decolonization, where the formal empires were eliminated and the former colonies became independent states. But A, they had to become states. They weren't allowed to be anything else. B, they had to use the borders that their colonizers had drawn up for them. And C, they were held to be bound by the treaties and contracts that their colonizers had made while they colonized them, which more often than not meant that an independent government came to power and found that most of its natural resources had been sold. And they had no right to nationalize without awarding compensation that they couldn't afford. So the former colonizers never let go. But starting with the oil and then financial crises of the late 1970s, we moved into this form of rule through the IMF and the World Bank. And in underdeveloped countries, it's the IMF and the World Bank that impose neoliberal policies that don't work. So, to put it in a very blunt way, Egypt could literally elect a communist tomorrow and nothing would change, because Egyptian economic policy is not in the control of the Egyptian government. So the other continuity I wanted to talk about is a continuity of colonial governance. So there were essentially three modalities of colonialism. There was settler colonialism, like the USA or Israel or Canada, which is predicated on the desire to eliminate the natives. It's a genocidal vision of colonialism. There's direct colonialism, which was generally the French model, where you move troops and bureaucrats and everything out to run a country. And then there was indirect colonialism, which is what the UK preferred. So instead of you running the country, you co-opted the local elites to run the country for you. And as I see it, the local elites were given two jobs. Job one was to extract as many resources as possible. And job two was to keep the population under control, to pacify the population. In return for that, they got military support, political patronage, and the right to skim off some of the proceeds of the resources that were being extracted. And I don't think anything's changed. I think now, under contemporary neo-colonial governance, the governments of underdeveloped countries have two jobs: to extract as many resources as possible and to maintain order. In return, they get three privileges. So instead of military protection, they get the right to buy arms or have their soldiers trained. They still get diplomatic patronage and protection, and they still get the right to skim some of the proceeds of the money being looted. So I think that I don't know that I like this analogy, but I feel that governments in underdeveloped countries are like concentration camp commanders. That they're doing a terrible job because it's their job to do a terrible job. And if they don't do it, they'll just be replaced by someone else who will.
So the system is based on whoever is not going to play their part. There's just going to be another one who's going to play it anyways.
Yeah.
So you have to remove the whole system to begin with.
Yep. I mean, so there's an article that I give my students, which is, and I'm just going to give the title because it's very self-explanatory: the 23 African presidents killed by France since 1960.
Okay.
Then you have to add the ones the Americans killed, the ones the British killed, the ones the Belgians killed. And you see a very clear pattern. Any state that attempted to move from formal independence to actual freedom had their government eliminated.
This is what mostly will happen with South Africa, I believe.
South Africa, it starts, I guess, with Mossadegh in Iran in 1954, where Britain and America arrange a coup. Then you have Lumumba in Congo in 1960. You have Nkrumah in Ghana in the mid-60s. Sankara in Indonesia. Like it's a terrifying list of people that have been deposed and killed by the so-called democracy-promoting Western governments.
That list is pretty long at this point.
When we go to, when we see it in this way, like it's very smooth and makes sense and to give us nightmares. But I would love to ask, is any side from the legal international institutions, the internationalization, any of them has make a positive move or a positive effect, influence toward justice?
My short answer will be no. But it depends what you mean by positive. I think there are institutions that I find problematic, like the UNHCR, the IOM, the World Food Programme. And I can't say that what they do is positive, but it definitely stops things being even worse than they are now.
Okay. So it's damage control.
Yeah.
What's happening?
But it's the important thing is it's damage control for what the rest of international law is doing. You know, think about it. If we stopped stealing $3 trillion a year from the underdeveloped world, there would be no migration crisis in the world. No one leaves India or Africa to come to Britain for the weather or the food. They're coming because it's the only economic opportunity that they see. They're coming because we stole all their money already. If we just stopped doing that, I think they'd be happy to stay at home.
And from a white man perspective, is that justice?
From a white man's perspective, there's always justice. From my perspective, no.
And how do you think the white man sees justice? And then I want to go.
The white man sees justice in the belief that everyone should be treated as if they were white men, and in the belief that everyone is treated as if they were white men. It's why white men have so much of a problem with feminism and race theory, is that they both say, actually, white male life isn't normal. White male life is quite unusual on a global scale and unusually privileged. So if you are in a position of privilege, then the world tends to look quite just. If you're in a position without privilege, it's much easier to see how unjust the world is.
Okay, yes, I understand. And now I would love to ask your personal definition to justice. It's my chance to ask you.
You
Been
won't?
looking for this for a couple of days now.
Oh no, you won't like it.
Because yes, because it's clearly to maybe to the reader or the audience seeing that it had a big role in your career and involved in your career. The definition of justice played.
I think I want to be a tiny bit pedantic here. I think that injustice has played a big role in the development of my thinking. And I hold a position that's not philosophically popular and may not be philosophically coherent. But I believe that you can recognize injustice without knowing what justice is. It's also noticeable that on balance, until very, very recently, my critique of international law is fundamentally an economic critique. And I believe that we could have an economically more just world. But beyond economics, things get much, much more complicated. So, I mean, to take a really cliched example, in a just world, should a Muslim be allowed to change their religious faith? Which, from a liberal perspective, evidently they should, and from a Muslim perspective, evidently they shouldn't. We have two very different understandings of justice going on here. What I say to my students is that justice is impossible, but more importantly, justice is undesirable. We want to minimize injustice, but to maximize justice, we would need to decide whose justice to maximize. And it seems to me, and I'm being very deliberately polemic and simplistic here, but two groups of people who are definitely pursuing justice in the world are the zealots of the human rights movement and ISIS. And they're pursuing two very different justices, but they both have the idea that they know what is right for everyone everywhere. And I find that kind of certainty exceptionally frightening. So I want all of my students, all lawyers, all people to fight injustice. But we have to think very, very carefully about when we can impose our specific understanding of justice.
But as you said earlier, because they believe that judges have the chance to go with this decision or another way for decisions they want.
So one of the things that I've noticed, which I find really interesting when I teach at AUC, is that most of the judges I get don't actually realize that. They've genuinely bought into the ideology that they're applying rules. And what I find really curious is that it's relatively easy to persuade judges that actually, no, you're not. You're making things up. But for some reason, and I have no hypothesis at all, it's really hard to persuade prosecutors that judges are making things up. Judges, yes, they'll accept it. Prosecutors, no. And I don't know why that is. But what realism wanted to do was to undermine the whole mythology of rules, the whole mythology of an objective and impartial law, and to say, no, law is inherently political. Making law is political, applying law is political. Let's bring that politics to the surface, because if it's a good politics, then it should be happy to be on the surface.
Yes.
If it's a bad politics, then we should bring it to the surface to change it.
Yes. And I believe maybe judges are maybe with the future more mature, but they have a lot of publicity and propaganda for rule of law, equal justice, and maybe the word justice, we can't hear it a lot anymore. It's always the rule of law and rule of law is the only solution.
Yeah, this is part of a worrying and wider trend that is worth thinking about. So on the one hand, there are benefits to the rule of law. We just shouldn't see it as an absolute good. But on the other hand, the meaning of the rule of law is subject to change. And in particular, there's a convergence in international law between the discourse of development and the discourse of the rule of law. And I find this is a very worrying trend, because the discourse of development is based on bad economics. If the aim is to bring those bad economics into the rule of law, then the rule of law will actually become a bad thing.
I'll be clear on that.
So rule of law, yes. Rule of neoliberal law, no.
Yes. And I have two questions. Only two questions. Just trying to find, because many of them you answered through the question. Yes, and this one question. What your share on the source of the tension between legal positivism and natural law theories, and how does these philosophies influence our understanding of the moral foundation of law?
So there are at least two different kinds of legal positivists that I roughly call empirical positivists and ethical positivists. So empirical positivists are saying legal positivism, the idea that there's no necessary connection between law and morality, is the most accurate way of describing the practice of law. Empirical legal positivists, on the other hand, are saying, I've just lost the word completely.
It's okay, take your time. You've been a lot.
Ethical legal positivists are saying not that legal positivism is the most accurate description of law, but it's the most preferable description of law. So positivism is based, as I said, on this idea that there's no necessary connection between law and morality. And what that means at a practical level is that those applying the law should ignore their own morality and apply the rule as it's written. And the argument, very simply, is that that gives certainty to the citizens and it limits the discretion of the judges. Natural law is kind of unified by the opposite idea, that there is a necessary link between law and morality. But then you get this fracturing in natural law, which is based around the question of which morality should law have this necessary relationship to. So when natural law first came to prominence, which would be around the 12th century, at least in the Western world, Christianity was still Catholicism. It was still a whole discourse. The Reformation hadn't happened. And so it was obvious to everyone that the justice that was being talked about was Catholic justice. So that made sense. But in the modern world, we're stuck with this question. Do we mean it should be linked to Catholic justice? Should it be linked to Islamic justice? Should it be linked to liberal justice? Is liberal justice even a thing that you can link it to? Should it be linked to economic justice? Should it be linked to racial justice? And so I've never really understood the attraction of natural law. And I take a very simple example for why I think positivism is superior, which is the issue of abortion. And as I'm sure you know, the issue of abortion is morally very, very clear. Right? Killing people is wrong. Killing innocent people is more wrong. There is no person more innocent than an unborn child. Therefore, killing an unborn child is morally wrong. Clear and incontrovertible. On the other hand, people have control over their own bodies. Bodies include reproductive functions. Women are people. Therefore, women should have control over their reproductive functions. Therefore, abortion is morally necessary. So abortion is simultaneously morally prohibited and morally demanded.